what do you think this is going to ultimately end up with as far as courts putting this into practice?
Yeah, that's a great question, and I think it's really an open question, and it's something that I think people have some concerns about. Right? How is this focus on history going to be implemented and applied, especially at the lower level of the federal court system, right? With district courts, when you consider that the Supreme Court in Bruin had the benefit of hundreds and hundreds of pages of amicus briefing, expert historians, right? I mean, they had a lot of resources available at their disposal to unpack the history here and to kind of figure out exactly what historical laws were around, right? And then they can take those laws and analyze them. And there's some concern about how judges at the district court level, I mean, at the appellate level, there often are amicus briefs. They have maybe more resources, but at the district court level, judges don't really have experience in doing history in that way, and they don't have the benefit of amicus briefing. It's kind of unclear. I think there are, something that we've seen and will probably continue to happen is that we'll see historians being called as expert witnesses. But I don't know the answer. And there's an interesting footnote in the majority opinion where Justice Thomas responds to Justice Breyer's point on this, right? Justice Breyer sort of raises this question of whether the framework will actually work in practice. And Justice Thomas says, well, we rely on party presentation, right? So you rely on the government to come forward, to do the historical work of kind of figuring out what laws might be analogs, and then the challenger can kind of take those apart and say, here's why I don't think they're analogous. And I think that's certainly a fair way to look at it, but I think there are hard questions out there. Like, for example, what do you do if neither party raises a law that then at the appellate level gets, somebody writes a brief and says, hey, nobody brought this to the court's attention, but this is directly on point, right? You can even see instances where there are, new archives discovered, or, this is not kind of a static thing, right? As we're going back and looking at the historical record. So I think there are going to be some, there's going to be some growing pains, certainly. I don't know how exactly the lower courts will do this. And I think it'll vary a lot depending on what kind of resources they have and who the parties are in the case.
Yeah, that's probably true. I think that's probably a critique you could give of, balancing tests as well. How does a judge balance whether or not, a law is narrowly tailored to meet a compelling government interest? Like, it's a lot of it's judgment calls, right? That's right in the name of the.
I think that's
job,
fair.
right?
I think the thing I'd say on that is that it's interesting, right? Because when you're looking at historical laws, the idea behind a lot of originalist thinking is that these are facts, right? You're finding facts, right? You're not dealing with legal arguments. So,
right.
There's generally deference to fact finding, right? But the fact finding is here, who is going to do the fact finding, right? And that's sort of the question: how are these facts going to come before the court? Will there be deference given to the facts that are found at the district court level, at the trial court level? Should there be? So I think there's some questions here. I think it's going to be a little bit different than what what had happened under the two-step framework, right? Because there you're dealing with arguments that the government's making, saying this is why X law is empirically is going to accomplish our objective of public safety or something like that.
Yeah, of course, the common critique of that two-step test was that it almost always upheld whatever gun regulation was being challenged, and I think maybe that's part of why. Like one thing I wonder is whether the court kind of got fed up with what the lower courts had been doing, especially places like the Ninth Circuit, which was just upholding everything. Which a lot of gun rights advocates obviously got very fed up with that. But do you think that played a role in the courts, the way they went about handling this case?
I think that's probably fair. I mean, you can see some of that coming through in, Justice Thomas, for example, had dissents from denials of certiorari over the years, right? Where he said, we're not, lower courts are not faithfully implementing Heller. So I think that's definitely part of what's going on here. It's interesting, and you actually brought this up earlier, right? It's interesting that the historical tradition test, we'll call it, that the court actually implements in Bruin. This is something that post dates Heller, right? This is Judge Kavanaugh, Justice Kavanaugh, when he was a judge on the D.C. Circuit, kind of is credited with pioneering this test in, I think, 2011 in that Heller 2 case. So it's not that and there's a lot of debate between the majority and the dissent over what did Heller say? Did Heller rule out tiers of scrutiny? Did it just leave the question open? But yeah, I think as it became clear how what test was being adopted at the appellate level, I think there was certainly frustration among the originalists on the court that this is not what we meant in Heller. Was it clearly explained in Heller? I don't know. I think that's a matter that can be you can go back and forth on for a long time, but that's definitely part of what's driving the decision here, I think.
Yeah, I mean, Heller was, I think a lot of this comes out of the fact that Heller was a compromise decision. They needed Kennedy to be on board to vote for it, and Kennedy didn't want to write a ruling or sign on to a ruling that had extremely broad-reaching consequences immediately. Right. I don't know. Like, they just wanted to deal with can you ban all handguns for use inside of the person's own home? You read Heller and it's setting up this, here's the bare minimum of what the Second Amendment protects. And to assuage any concerns about, just radically reworking the whole system overnight of gun regulation in the United States, they put in a couple paragraphs that said, look, this doesn't, there's all in theory, there's the things you can do. It doesn't mean that there's no regulation possible. It's not an unlimited right. That's what what Scalia wrote in there. And, so you had to build out a comprehensible test from that ruling. And that's what Kavanaugh tried to do because, all right, well, how did Heller come to this decision? That says some regulations are acceptable, some that might not survive, for instance, strict scrutiny, could still be constitutional under the Second Amendment. Things like the National Firearms Act, the ban on M16s, right, which is explicitly mentioned, or at least alluded to talk specifically about banning M16s. But, how can that be constitutional under the Second Amendment, under strict scrutiny point of view? Well, we're not using strict scrutiny. We're not using balancing tests. We're using this specialized look at history and tradition of the United States. And so now they've built that test out into something more formal in Bruin. That's how I look at it. I don't know if that matches with how you view that evolution.
I think that's certainly the intent, and that's certainly the idea. I think one way, and it's interesting. I was looking this morning back at the oral argument in Bruin, and this comes up a lot. Justice Barrett raises this when they're sort of talking about there's this back and forth about what could New York designate as a sensitive place? Could they Times Square? What about Times Square during New Year's Eve? Justice Barrett says essentially doesn't this all come down to levels of generality? Right. She says, isn't this all just a question of, at what level of generality are you examining the historical record? And, in Bruin, I think the court pretty clearly takes a narrow view, right? The court says, look, we need to find a historical analog of a state limiting public carry to people who showed some special need, right? I don't know that you could get any more specific than that, right? That is what the New York law does. You could certainly get broader, right? You could say, well, we're looking for laws that restricted people from carrying weapons in public in dangerous ways, right? There are infinite levels that you could do, but you could go up. And I don't know, a lot of how this test works in practice will be at what level of generality do judges apply it. And it's going to be tough for judges to be consistent. I think we're going to see variation in different circuits. I think we're also going to see variation in these different categories of challenges that we'll see, right? So we'll see challenges to where restrictions, right? Location restrictions, sensitive places. We'll see, who challenges, right? Challenges to what groups can be prohibited from possessing guns. We're going to see challenges to what, right? To what type of weapons, assault weapons, magazine bans, things like that. And I think there's definitely going to be some, there are definitely going to be judges that, allow their own opinions about the law, allow their proclivities, their feelings about the law to sort of dictate how they do the historical analysis, at what level of generality they do it. You can think about things like, the sensitive places doctrine, right? And the sensitive places cases that will come up, right? At a high level of generality, you could say, well, what are the historical laws where legislatures, banned guns in locations where they thought guns were especially dangerous, right? That would be the high level. A lower level might be, if you look at what Justice Thomas identifies in the opinion, it might be something like, places where people engage in important political activities, right, or things that are central to the democratic process. And I don't know how those will come out, but I will say that I think there's a lot of room there, and I don't know. I'm not sure that the framework is as constraining of judicial discretion as the majority might hope.